Namaste. Good afternoon. Thank you. So, packing my bags to go on this trip, and my 8-year-old son was talking to my wife. And my son had said, "Mom, why is Dad going away for so long?" She said, "Well, he's got a lot of meetings. He's meeting with some very smart people to talk about what he does for a living." And he said, "Well, Mom, if they're so smart, why do they want to hear what Dad has to say?" And I thought, okay. So my hope is I can impart at least some words of wisdom to you and will surprise my 8-year-old son. So recently in the United States, Congress, in its infinite wisdom, concluded that litigation is just too expensive. And they wanted to provide a less costly, more time-efficient method of invalidating patents without having to go through litigation. Inter partes review, and I know IPR means something different in India, but the acronym we use is IPR, and I'm going to walk through IPR in the context of Hatch-Waxman litigation. Now, I've made my slides available for all the audience members. Here in India, many people are very familiar with Hatch-Waxman litigation, so I'm not going to focus on the tenets and the foundation of Hatch-Waxman litigation. Instead, what I'd like to do is just go straight to a comparison and contrast of Hatch-Waxman litigation and what we call IPR, inter partes review. So at the outset, we see immediately that a litigation will typically cost between $3 and $5 million. That's per side through trial. In contrast, an IPR is about 10%, 1/10 of that cost. So you can see immediately there's a huge driving force to prefer an IPR, when relevant, over litigation. The IPR is also initiated by the non-patent holder. Litigation, within the context of Hatch-Waxman, is initiated by the patent holder. The timing to file an IPR, it needs to be done within 1 year of being served. So that means if you are a generic pharma company, for example, you can file the IPR even before you're served or up to 1 year after being served. Just understand that once litigation starts and you are served, you will ask the court for a stay of the litigation pending the outcome of the IPR. Now, if litigation has started, that stay is not an automatic right. It's not guaranteed. But if you file your IPR before litigation starts, by definition, there would be no stay because there is no litigation. The grounds for asserting invalidity in IPR is somewhat limited compared to litigation. An invalidity position in litigation would be available with any invalidity or unenforceability issues. 101, patent ineligible subject matter. 102, anticipation. 103, obviousness, as well as 112, lack of written description, lack of enablement, those types of issue. In contrast, an IPR can be based only on a prior art invalidity position. For example, 102 and 103. So just understand, as long as your position is based on prior art, you're fine, but you cannot bring 112 issues, for example, with an IPR. The ability to have the reviewing board consider prior art that was previously considered is also significant. With litigation, you can always ask the judge to consider prior art that was previously considered, but the judge will give a lot of deference to the examiner. That's not the case in an IPR. With an IPR, the panel of administrative patent judges, APJs, would be more likely to consider prior art that was already considered by the examiner. The threshold for patent litigation is a reasonable basis in law and fact for the claim. With an IPR, it's a little higher. It's a reasonable likelihood that the petitioner would prevail. So you need to have a good faith belief that you would prevail within the proceeding. So there would be no what we would call sham types of filings for an IPR. Another negative with an IPR is the issue of estoppel. So unlike litigation, with an IPR, you are estopped from asserting the same prior art or even prior art that you should have been aware of in any later litigation. So you, as the petitioner in IPR, need to be aware that you are using what you consider to be the closest and the best type of prior art, because you can't sort of hold anything in your pocket, so to speak, wanting to use that later on if there was litigation. I think another very key element of an IPR is who the decision maker is. In the United States, there's no requirement for judges, even those judges who decide patent cases, there's no requirement that that judge have a technical background. So very often, the very judge who's hearing a patent infringement case or a patent invalidity case, that person does not necessarily have a technical background. And oftentimes, the person does not have a technical background. So we're talking about somebody who went through undergraduate, college, maybe majoring in history or sociology, English, these types of subject matter. They're not going to be somebody who would readily understand, for example, what an enantiomer is. They wouldn't even understand the meaning of weight percent. So these are people who hear the patent cases. Now, they may be very intelligent and educated people, but they just don't understand the technology. In contrast, the APJs are going to be patent professionals, oftentimes former senior examiners. And so these are people with a high technical understanding, somebody who's examined cases in a particular art unit for many years, or is going to be a patent attorney, somebody, again, who has a technical background. So the other feature is with a APJ or with an IPR, inter partes review, you're going to have a panel of 3 APJs as opposed to litigation where there's 1. So again, you'll have 3 people, all with technical backgrounds, presumably at least one whose technical background matches or aligns with the subject matter of the patent. You can understand that these are people who will understand the technology and will not be reluctant to dive into the details of the patent. They'll ask very insightful questions. These are people who are very proficient in the subject matter. So we mentioned at the outset that the cost of an IPR is so low. And you may ask yourself, why is that the case? There's still a trial in this proceeding, but why is the cost of this trial so much lower than the cost of litigation? And part of it is the expansive discovery that occurs in litigation and the relatively narrow scope of discovery that occurs within an IPR. So for example, for those who may have experienced a litigation in the United States, your colleagues, including senior members of your group, maybe the VPs, maybe even the president of the CEO, may have been deposed. So the company or the law firm sends out a team of attorneys. They come here, they meet with people for days. You'll have your attorney defending your depositions, and this is very expansive. They go through volumes of emails, and this just runs up the costs over a period of time. So anybody who could be deposed will be deposed. If nothing else, the other side's going to want to find as much information to support their case. In contrast with an IPR, what you have is only the declarant, only the people who provide an expert report, right, with the formal documents to the Patent Office, only those people will be deposed unless there was good cause to depose somebody else. So what you have is maybe 1 or 2 experts per side. Those will be the people, and typically only the people who will be deposed. The other aspect is the depositions will occur only in the United States. So they're not flying out a team of attorneys here, on both sides to take depositions and defend depositions. So you can see immediately there's a much shorter time period that this will occur over. There'll be less people working on these projects, and there'll be a lot less costs associated with it. So another benefit is, as the IPR petitioner, right, the expert witnesses that you have do not even need to be employees of the organization. You can hire, your attorney can hire an expert witness who's not employed with the organization, and typically with a litigation, questions will be asked of your colleagues of, why did you do this? Why did you not do something? Were you aware of this patent? What was your thought of the patent? And they try to probe to find some very damaging statements that you'll make. When you hire a non-employee, they will not be able to answer those questions, right? So the deponent will ask questions of, why did this person in India, do A or do B, or were they aware of the patent? And the typical response is going to be, I don't know. You'll have to ask them. I don't even know this person. I've never met them. So it cuts down on the time and the costs during discovery. And discovery is a big part of the high cost in the United States for litigation. So standard to prove invalidity is also very favorable for an IPR compared to litigation. The burden is clear and convincing evidence for litigation, which is about 80%. For an IPR, it's preponderance of the evidence, which is about 51%. It just needs to be more likely than not. The sort of 1-2 punches with an IPR, there's no presumption of validity. So in the United States, when a patent issues, there's a presumption of validity. There's a presumption that the examiner did his or her job correctly, and the patent issued when it should have issued. With an IPR, there's no such presumption. The panel will initially take the perspective of, it could be valid, it may not be valid, we'll investigate it, but they don't start from the position of, it's valid until somebody proves it to be invalid. So this combination is huge. So you can see that it's going to be more likely than not, compared to litigation, that a given patent would be held invalid. The claim construction is also very significant for an IPR. Under litigation, the courts will take a reasonable claim construction, and the courts will follow a litany of steps to figure out what the meaning of a various claim term is. They'll look at the plain meaning, they'll look at the patent specification, they'll also look at the file history. Those are called the intrinsic record. And they try to come to an understanding as to what the patentee really meant when they used a certain claim term. In contrast with an IPR, the APJs will view it from a BRI, broadest reasonable interpretation. And this is really significant because now, with a broadest reasonable interpretation, you have more as opposed to less prior art being relevant. The more prior art that's relevant means the more prior art that's available to invalidate the patent claim. The time for decision statutorily is 12 months with an additional 6 months for good cause. As we know, a Hatch-Waxman litigation will typically take at least 2.5 years. It's very rare for it to conclude within that 2.5 years. So we see immediately the high end for an IPR is still below the low end of a litigation. Both parties can appeal to the Federal Circuit. I'm leaving some slides on joinder and guidelines for discovery and depositions. I won't go through it because I think it's a lot of very specific detail. Last 2 points I wanted to make. The first is, as good as IPRs are, or at least viewed, the prevailing wisdom is that you would not use an IPR when you have a first to file. And the reason is this issue has not been addressed in the law and has not been addressed by any courts. But the prevailing wisdom is, with an IPR, the applicant would not be entitled to the exclusivity. So first to filers are not even considering IPRs for the most part. That may change. Somebody may think of a new strategy or may have a different perspective, but right now IPRs are usually filed with second and third filers, or even with patents not listed in the Orange Book. The last seminal point I wanted to make is, with an IPR, there is no absolute right to amend claims. So typically, claims are canceled, and the equal amount of claims are substituted. And for those changes in the claim, you need to, the patent owner needs to convince the APJs that such an amendment would have been appropriate. So you can't have new matter, and it needs to be a claim amendment that obviously the panel will decide upon. So even the ability, once relevant prior art pops up, just the ability of the patent holder to get around that prior art, there'll be more limited options as opposed to if that patent or application were in prosecution. And I think the point to remember is with an IPR, the panel of judges are not examiners. They're not examining the case, so they're going to be very reluctant to allow these types of changes of the claims to be made. They'd rather that to be done with an examiner, not the panel. So with that, I'd like to thank the host for inviting me to speak today, and I will certainly be around for questions later. Thank you. Or should I take questions?